Hi, everyone. My name is Jane McElligott. I'm a professor in the School of Legal Support and Services here at Purdue Global. And in honor of Women's History Month, I would like to talk about Ruth Bader Ginsburg, the famous justice, as well as a strong advocate before the court for women's rights. And the first case that she made a huge score in on that front is Reed versus Reed, which was 1971. This is an equal protection clause. So just to start off, just a quick little overview of the equal protection clause. So the key language of the equal protection clause in the 14th Amendment of the Constitution states that no state shall deny to any person within its jurisdiction the equal protection of the laws. So the state cannot deny a right to one class of persons that it provides to other classes of persons, unless there is some kind of justifiable reason for that differential treatment. So, for example, a lot of laws may treat motorcyclists different than those in cars. So there are many states that require motorcycle drivers, but not car drivers to wear helmets. And of course, these laws have been challenged, but the courts will uphold them because it's justifiable because there's so much more of a likelihood of serious injury if someone on a motorcycle is in an accident. They're likely to face serious head injuries, but in a car, of course it could still happen, but a person has a roof over their heads in a car, so there's much more safety measures in a car versus a motorcycle. So it would be justifiable. The state, if this type of law was challenged, the state would raise that reason. The court would say, yep, okay, that's a valid reason. And it passes what's called the rational basis test. Of course, when a state treats people differently because of their race or national origin, there's not going to be any justifiable reason for that. It's going to be discrimination. The only kinds of laws or policies that have been upheld under this is if the differential treatment is because of a beneficial called benign purpose. So, for example, for years, the court until 2023, this past summer, the court was fine with measures of affirmative action because it was decided that that is a necessary remedy to make up for years and years of past discrimination. And it's really in the interest of educational diversity, which makes everyone's education better. Unfortunately, the court struck that down in 2023. So really, there's probably no law would be upheld under this, even a beneficial law under the Equal Protection Clause. But what happens when the state denies a right to women that it provides to men, or otherwise really gives differential treatment or treats women differently than men? Is that a denial of equal protection? Well, that really wasn't known for many years until the case of Reed versus Reed in 1971. So it's an interesting case because this is the first one where Supreme Court of the United States, SCOTUS, held that the unequal treatment of men and women based solely on sex is a violation of the 14th Amendment Equal Protection Clause. So Ruth Bader Ginsburg at the time was a law professor at Rutgers. She wrote the winning brief to SCOTUS on behalf of Sally Reed, who was the plaintiff. So the facts in this case, Sally Reed and Cecil Reed had been married, but then they divorced. Cecil Reed really wasn't involved in their child's life, their child Richard. So the court easily awarded Sally Reed custody of Richard. But then as Richard became a teenager, he kind of got into trouble, nothing major, but not following the curfew and a little bit of trouble here and there. So the court removed him from Sally's custody and sent him to live in a children's home. This is the late 60s, this is going on. And then the court decided to award custody to the father, Cecil, with the idea that maybe he needed of course, gender stereotypes again back then, he needed a father figure and he would straighten him out. Sadly, though, Richard committed suicide while living with Cecil. He was at home in the basement and committed suicide. And so, of course, both were upset. Both decided that they wanted to administer his estate. He left behind a very small estate. He had a musical instrument he loved to play. He talked about studying music in college. So his mother, Sally, established an account to help pay for Richard's college education when the time came. And I should say he was though I guess I did say he was 17 at the time. But it was a very small amount that she was trying to, add to, just a little bit over $400. So a small estate for sure. Because Sally had established the account and she kind of didn't trust Cecil, she petitioned to be the administrator of her son's estate. Cecil, though, also applied and actually told her that she was too dumb to handle it. So talk about the stereotypes there. So the Idaho probate provision that was at issue here specified that when a child dies intestate, so meaning without a will, which was the case here, he did not have a will, the father and the mother are both listed under the probate code as being equally qualified to be administrators. But then the code goes on to specify that of several persons claiming to and entitled to administer the estate, males must be preferred to females. So in other words, if there's a clash, if there's a challenge to get the letters of administration, which would mean that person is appointed administrator, the court just says, okay, the male wins. Female and male wins. And so based on that provision, the Idaho County Court granted the letters of administration to Cecil. And in an unanimous upholding of the county court's decision, the Idaho Supreme Court wrote, philosophically, it can be argued that the Idaho Probate Code provision does discriminate against women on the basis of sex. However, and get this language, nature itself has established this distinction. The legislature, when it enacted this statute, evidently concluded that in general, men are better qualified to act as an administrator than are women. So again, talk about gender stereotypes just rising to the forefront here. So Sally Reed was quite upset. She decided to keep going, and she decided she's going to bring this all the way to the Supreme Court. And by the way, in Idaho, she had a very tough time getting an attorney to take her case. She went through 16 attorneys to finally get one who would take it, and this one was very dedicated and willing to go all the way up to the Supreme Court. Luckily, RBG, Ruth Bader Ginsburg, who at the time was not a justice yet, she was teaching, and she had just started up on kind of part-time the Women's Rights Project for the ACLU, the American Civil Liberties Union. So she jumped in knowing this would be an excellent case to pursue, and she wrote the winning brief to SCOTUS. She knew that this is, just a case full of outdated gender stereotypes, and it would be a perfect one to challenge the laws that are based on stereotypes as being violations of the 14th Amendment, Equal Protection Clause. So on the major issue before SCOTUS of whether the Idaho Probate Code provision at issue violated the Equal Protection Clause, the justices of SCOTUS answered with a resounding yes. It was a unanimous decision. So the state of Idaho, of course, tried to defend its statute and the code, I should say, and they argued that, well, when both the mother and the father are equally entitled to be administrator, or in other classes where there's a male and a female contending to be administrator, the preference for the male applicant was a way to avoid hearings on the merits. Also, the state said that handing the letters of administration to the male in such a dispute would be a way to avoid intra-family disputes. So in other words, we can, by doing this, by having this outdated approach, we can avoid hearings, save the court money and time, and also keep the family intact. So that was the state's reason. But the SCOTUS did not buy it. And SCOTUS went ahead and struck down the Idaho code provision and found the state's justifications to be very unworthy of upholding such a discriminatory law. And the SCOTUS declared to give a mandatory preference to members of either sex over members of the other, merely to accomplish the elimination of hearings on the merits, is to make the very kind of arbitrary legislative choice forbidden by the Equal Protection Clause of the 14th Amendment. And whatever may be said as to the positive values of avoiding intra-family controversy, the choice in this context may not lawfully be mandated solely on the basis of sex. So a very powerful decision. And just one of many that Justice Ginsburg fought for in a line of cases that she fought for women's rights, for equality. And this is one of her famous quotes, one of many famous quotes dealing with the Supreme Court. When she was a justice, she said, "When I'm sometimes asked, when will there be enough women on the Supreme Court? I say, when there are 9." And of course, there are only 9 justices. And people look shocked. But she said, but there have been 9 men, and nobody raised a question about that. So with that, I leave you, and I will bring in more Ruth Bader Ginsburg's cases soon. Thank you, everyone.